Hello, everyone. Welcome to Court with Krissy. According to Jake from State Farm, a horse cannot be an uninsured motor vehicle. But according to the driver that hit a horse that got loose after a guy rode it to the bar, yeah, it is an uninsured motor vehicle. Judge Tammy Long Hayward is going to have to decide. But we don't get her decision. She's got to think about it. And I want you to think about it and let me know in the comments what you would do if you were the judge. I hope you like it. Court with Krissy is now in session.
All right. So let's begin with Wilson versus Terrell. No, I'm sorry. Green versus Johnson. Sorry, Wilson versus Terrell. I was right.
Thank you. I'm Abigail Moody for the plaintiff. It's defense's motion for summary judgment. So do you want them to go first?
Yeah.
Okay. All right. Good morning, Your Honor. Ryan Brightman here for State Farm. I think this is a relatively straightforward question. Really, just one issue is in default. In dispute. There's no real factual questions as pertinent to our motion. State Farm is moving for summary judgment on the single issue. An argument that there is no coverage for this loss under the plaintiff's uninsured motorist coverage. This accident is a single vehicle accident that involved a horse that belonged to Jamario Terrell. Apparently, Mr. Terrell's horse became loose at some point, some way, and Miss Wilson's vehicle struck the horse. As you alluded to earlier when Your Honor was calling the calendar, Mr. Terrell has not answered or made an appearance on his own behalf, but we're here just to arguing that as a matter of law, State Farm is entitled to judgment because a horse is not an uninsured motor vehicle.
Could have said it, but I wanted to hear you say it.
Yeah. So, and I'm not trying to make light of any situation.
No, I get it.
Yeah. But
because I was going to ask if this was part of a homeowner's insurance policy that I'm not aware of, or because it's that doesn't support. But yeah, so they're bringing it on behalf of the person owning the horse as a vehicle.
So yeah, Miss Wilson has served State Farm as her uninsured motorist carrier. So yes, it's a pretty straightforward question, I think. And so a few different places that we can look for a definition of an uninsured motor vehicle. First, we'd look to the statute. The uninsured motor vehicle statute tells us what an uninsured motor vehicle is, but it doesn't define motor vehicle. For a definition of motor vehicle, we could look to the liability statute, which is OCGA 3334-2, and that defines motor vehicle in the liability context as a vehicle having more than 3 load-bearing wheels of a kind required to be registered under the laws of this state relating to motor vehicles designed primarily for operation upon public streets, roads, and highways and driven by power other than muscular power. And it talks about trailers and low-speed vehicles. Now, there is case law that has, and we cited in our brief, and as did Miss Moody, that has held that the definition of motor vehicle that I just read you is broadened in the uninsured motorist context. For example, the more than 3 load-bearing wheels. The court has suggested in the case of Hinton versus Interstate Guarantee Insurance Company, and that's cited in our brief. The court in Hinton suggested that, for example, a motorcycle only has 2 wheels, but could be an uninsured motor vehicle under the UM statute. The case in Hinton actually involved a tractor that was towing a trailer on the public highway. And so a tractor, of course, would not fall under a motor vehicle required to hold liability insurance as a regular car. But in that context, the Supreme Court held that that tractor did fall within the definition under the statute and Georgia law of an uninsured motor vehicle. So as far as that's the statutory and case law authority that we have from Georgia about what an uninsured motor vehicle is and what a motor vehicle is. There is the case of, pardon me, Georgia Farm Bureau Insurance versus Claxton, where the Court of Appeals was faced with a factual scenario after a parade. A couple of gentlemen were driving their mule-drawn carriage, and the Court of Appeals there found that the mule-drawn carriage was not an uninsured motor vehicle. And the only other case I could find on point with involving animals is another case would be Persuasive Authority from Kentucky that found also a horse-drawn carriage, whether it's a mule or a horse, was not an uninsured motor vehicle. I understand. Yeah.
May I ask, there was only the horse, there was no structure attached to the horse, no vehicle, no trailer or anything.
Yeah.
Horse wasn't pulling anything.
So in the case of the Farm Bureau case, the Court of
No, I
Appeal,
meant in the present.
In our case, no, Your
Okay.
Honor, it's just the horse.
Okay.
No trailer, no other structure attached to the horse. So yes, in the Court of Appeals case involving the trailer, part of the argument was about whether the carriage qualified as a trailer. But there was no such issue in our case. So I understand that the plaintiff in response argues that the UM statute is remedial in nature. The courts have held that it's to be interpreted in a way to protect the public. However, I'd argue that there still has to be the words still have to have a meaning. The commentator Jenkins and Miller, they have referred to UM coverage as insurance against lack of insurance. So even
that's the broadest interpretation of it.
Right. So here there's no law that would require it might have been a good idea. And who knows? We haven't been able to speak with Mr. Terrell to see if he had a homeowners or umbrella policy that might cover him. But there's no legal requirement that people hold liability insurance on their horses. So this isn't a situation where the UM coverage is essentially insurance against lack of insurance.
All right. The closest, I guess, scenario that I can figure that happens commonly is if someone's car gets hit by a deer.
Yeah. Yeah.
Like, they come out of nowhere, it's an animal. They're definitely not insured, but there have been no cases where someone can claim from their UM policy coverage for that type of scenario, is there?
No. So, and that's what I didn't want to again make light of the situation, but
I'm not making light.
It does. You wonder if we accept that a horse in this case is a motor vehicle, then is a deer, is a cow, is a goat, is a dog, is a cat, is a squirrel. If somebody just sees the squirrel in the road and swerves into a tree, is that that squirrel an uninsured motor vehicle at that point? So in the response, the plaintiffs argue again for the remedial nature and protection of the public for the UM statute. They argue that the horse was could be used like a vehicle. Mr. Terrell apparently may have ridden his horse to a restaurant that evening and tied it up. Not well, apparently, but tied it up. So the language that the plaintiffs focus on in Hinton is that an uninsured motor vehicle is a motor vehicle that It's not designed primarily for use on the public roads and are not required to have liability insurance, but which, at the time of the accident, are being operated on the public roads like a vehicle designed for primarily for that purpose. So even if we go with that definition from Hinton and accept the remedial purpose, the entire reason that there was an accident here is because the horse was not being operated, at the time of the accident. That's the part of the Hinton language that the plaintiff leaves out or doesn't recognize in their argument. So for those reasons, we would ask the court to find, as a matter of law and a matter of contract, that State Farm does not owe coverage to Ms. Wilson for this loss and issue judgment in State Farm's favor. Also included, I did not go into the policy language definitions, but the policy language definitions as well, I'm sure Your Honor can imagine, are do not include animals and horses in the definition of cars or motor vehicles or uninsured motor vehicles. And all that has been included and attached as a certified copy of the policy to the brief.
Okay. All right, Ms. Moody?
Yes, Your Honor, thank you. So as the defense counsel said, this accident was back in February of 2024. And my client is basically traveling along a public road, Anvil Block Road. And what happens is a saddled up horse comes out and hits her car. She tries to avoid it. And as defense counsel also pointed out, we don't know a ton about the circumstances. We know from the accident report, and then the defendant is in default. And so, of course, the allegations in the complaint are considered true. But what we have gathered is the defendant rode this horse up to a place called Aquatic Blue, which is a restaurant bar, from what I can tell, tied the horse up outside. And then at some point, we don't know when, the horse gets loose and comes into the roadway. Pretty extensive damage here. The vehicle, I don't know if I can share my screen, but
You may.
let's see if I can see it. How do I do this? Let's see. Sorry, Your Honor, I'm trying. Let's see. This is what her car looks like, just so you can have an idea. You got that? Okay. And so yeah, it's a pretty extensive damage. And it's about $63,000 in bills. She has dental work, she has glass, all that stuff. And so what happens is, of course, the defendant doesn't answer. And we've been able to find no other insurance for this. And so now UM is, in our case, what we consider up. And so State Farm is basically saying that the horse is not an uninsured motor vehicle, and therefore no coverage. And as counsel stated, the two arguments that they're using is, one, livestock are not uninsured motor vehicles under Georgia law, and second, basically the policy language. And so before I go into why I think he's wrong, I would first state, the summary judgment standard, which is that when the facts are viewed in light most favorable to the non-moving party, which is us, Plaintiff Jessica Wilson, there must be no genuine issue of material fact. And the facts must support judgment as a matter of law. And here I think that there is at least an issue. Now, what that issue is, but it has to be no issue to grant summary judgment.
Ms. Moody, if you can't articulate an issue, then how am I to assume that one exists? So here's where I am. The reason I asked about the deer and the reason I asked about structures attached to the vehicle, to the horse, is if you're telling me he's pulling a trailer or a wagon, then I can say, okay, it might not be motorized, but it is a vehicle. So that may be something that a jury, and I'm willing to take my chances with the appellate court. Not that I'm scared of them or anything, but at that point it's worth it. But at this point, I've asked if there was a structure attached to the horse, no structure attached. So I've asked about a deer, like if a deer comes out, it's not owned by anyone. If it hits your car, it can do the same amount of damage to personal and property to personal injury, but there's no way to sue a UM carrier for that.
Yes, Your Honor. And so what I would argue in defense of this, what I would articulate is this. So the first of all, the as I said, is supposed to be remedial in nature, right? And in that case of Hinton that he's talking about, there's two prongs that they get. They say there's at least two prongs that have to be included as what is a motor vehicle. And the court clearly says at least two. So they don't say exactly what those are, right? But the second prong, which is the one that, I keep on harping on, is the one that says that motor vehicles have to be included, motor vehicles that are not designed primarily for use on public roads and are not required to have liability insurance. And then, which at the time of the accident are being operated on public roads like a vehicle designed primarily for that purpose.
Which I would assume would be a dirt bike or an ATV.
Well, so I would say operated for that purpose. Okay. So when we say that someone took the vehicle, took the horse, saddled it up and took it just as you would a vehicle to a public place to have dinner, that is using it as a vehicle. I also have one other thing to show you, Your Honor, from the, if I can try to share it again, if you see, hang on, I'm sorry, I'm trying to do it. Share screen. Why is it not going? Let me see, I'm sorry. Here we go. This is where Your Honor, this is where the aquatic blue is. And this is somewhere around Boulder Crest is what we have the address for the defendant. We don't know how he got there, but clearly to get there, you have to cross some sort of a public roadway. So is it being operated in a public roadway? Yes. I mean, I would argue that yes, there's at least a genuine issue that it could be considered a vehicle in this. It's literally a vehicle transporting him into the lounge. So, I mean, that's how it's being operated. It's different than a random deer coming out, because a deer isn't that's just a random deer that's coming out into roadway, or a cow. This is something that is being used as a transportation in this case. Like the horse was taken as a vehicle to take the person as a car would to this restaurant. And so I would say that, that can fall, there's at least an issue that falls within the second prong. And then I would say in that Hinton case, again, the court articulates that at least those two categories. So even if you didn't think that matters, the court says at least. So I would say, again, that there's a genuine issue there. And then for the contractual part of it, I think that the contractual part is not as clear as Mr. Brightman makes it sound. It's clear that the uninsured motor vehicle in the policy, which we have as well, is defined as a land motor vehicle. But that term in the policy is not articulated. So hang on one second. So what is articulated in the contract is the term car, which is in one place. It's on page 4 of that policy, where it talks about the 4 or more wheels. And what Mr. Brightman wants you to do is use the term car in the term of basically transport that into the uninsured motorist definition, but that isn't there. In the uninsured motorist definition, which is, I can share that as well. The uninsured motorist definition, there's no place that it says car. And so I would argue to you that if they meant 4 or more wheels needed, then they should have used the term car. In this uninsured motor vehicle coverage, the term car is used in different parts of this language, and the property damage and the insured definition, but it is not used when it says uninsured motor vehicle. We only have land motor vehicle. And so because it does not have the term car, and yet car is articulated elsewhere in the contract, I would argue that there is some ambiguity there. And any ambiguity in a contract, of course, is strictly to be construed against the drafter, which is State Farm. So I would argue again, and that there's a genuine issue of material fact there. It's not enough to grant summary judgment and read my argument. And so for both the horse under Georgia policy and law and under the contract, I would argue that there's a genuine issue, and that I would ask the court to deny summary judgment.
I did notice that you're staying away from the word motor.
Your Honor, motor, we talk about like horsepower as motor, and I understand there is, I understand. I can't argue to you that that there's a motor on a horse. I mean, obviously I can't argue that. But what I can say is that, you know, it's being used as a vehicle in the sense.
All righty.
Your Honor, if I could just very, very briefly respond. I think we've covered most of the issues, but just in response, as far as land motor vehicle is the term used in the UM section of the policy. I think there's no ambiguity. The words have to have meaning. If it's not defined, you look to its plain meaning. A motor vehicle is a vehicle with a motor. You know, whether it has four or more wheels, one wheel, whether you two wheels, you know, something with wheels and a motor. The uh, uh, Lastly, to the point about the Hinton language and the Hinton language says that it's being operated at the time of the accident. If this were a case where Mr. Terrell were riding his horse from his ranch to the restaurant to the bar and gotten an accident, I still don't think it would be a motor vehicle, but we'd be closer to the Hinton definition than we are here. That's very different. It was not being used as a vehicle at the time of the accident.
All right. We will look more carefully at all of these definitions and give you an order.
Okay.
Thank you, Your
you.
Honor.
Thank you, Your Honor. May we
All
be
right.
excused?
Yes.
All right. Thank you.
All right.